Welcome, everyone. We're delighted to have you today. I'm Carol Razzo from ElderWorks. I am the Senior Strategy Director at ElderWorks, and we are so happy to have you join us with this town hall meeting with an elder law attorney this afternoon. If you we're going to let Nancie start shortly, and then we'll have time for questions, and we can sort of jump in between. So I'm thinking if you have a question, just send me a message in the chat box, or hold it briefly and we can kind of check along the way. Will that work for you, Nancie?
Yeah, or if they just want to stop me in the middle and ask questions, Carol, I'm fine with that too.
Okay, so then to do that, you'd have to unmute. Sometimes we get a lot of noise in the background.
Yeah,
so,
absolutely. Yep.
We'll see how it goes. So
Yeah.
Whatever works for you. If you have a question, unmute and just put your hand up because I'm watching and we can go ahead and have you ask it. So we're delighted to have Nancie Dorjath from Dorjath Law Center with us today. Their offices are located in Batavia, but I can attest to the fact that Nancie goes everywhere. So she's always available. They're wonderful, trusted partners with ElderWorks. As you know, ElderWorks helps seniors, families, and professionals finding any kind of services you need. We are very big on education. I hope some of you were able to attend our senior expo that we had the week of the 9th of August. Boy, that seems like yesterday and we're already going into September. So we're always here for housing information, for in-home care information, rehabilitation information, and then of course, we also are working hand in hand with our trusted elder law attorneys, financial planners, and all of the other resources that are available. We're non-for-profit, so we don't charge for our services. So it's people like Nancie that put us in a position to be able to bring all of the good information to you. And she's a wonderful attorney, easy to work with, and I might say quite fun as well. So Nancie, go ahead, please introduce yourself, tell them a little bit about your background and so forth, and we'll start.
All right, that sounds good. So thanks, Carol, for allowing us to have this opportunity to get the word out to the general public, because you know how important it is for people to be informed and not sometimes just go with what their neighbor told them to do. So again, it's very important that we all have the right resources, and Carol is a great resource for anything. I mean, again, I will give Carol's name out for things that I'm not aware of, because she's the general resource that I'm going to use, because they are a free service and we should take advantage of that. So I like taking advantage of Carol as much as possible. So we should all feel that way. So again, my name is Nancie Dorjath. I am an elder law estate planning attorney, and you're like, what the heck does that mean? So an elder law attorney, most elder law attorneys want to approach life, approach estate planning from a different point of view. A lot of estate planning attorneys, I believe, really care about what happens to you when you die. Well, which is great, because we're all going to die and we're all going to worry about that. But I'm more concerned with what happens to you while you're alive. If something happens, if you're in a car accident, if there's an accident, who's going to take care of you? Who's going to make the decisions? And really, what is your focus going to be? Are we prepared for that unexpected? So I take a more holistic approach. I want to find out what's going on with you. And I believe most elder law attorneys should feel this way. What's going on with you? What's your family dynamics? What's important to you? And how do we make sure that what is important to you is carried on while you're alive, but also when you pass away? So it's a couple of things that I truly believe people need. And I was just in a meeting, came from a meeting just before this. And, clients sometimes think, oh, but I have that, or my family's going to be able to figure that out. Well, I'm here to tell you, most families can't figure it out. When we're in a crisis, our brains don't think the same way. And when we're in a crisis, we need to be prepared. I kind of give the analogy of you know, if you're in a car accident, you're not calling State Farm 2 minutes after your car accident to get car insurance, right? We want to be prepared for the unexpected. And just because we have car insurance doesn't necessarily mean we're going to go and get in a car accident. We have them for that just in case, right? A friend of ours, literally his house was just struck by lightning a couple of days ago. He wants his homeowner's insurance to pay for that, to be prepared. What happens if he didn't have homeowner's insurance? So again, that's how we need to rethink these documents. It's who's going to help us when we need that help. Excuse me. And it doesn't necessarily mean we need the help forever. It could be for short durations. So again, I think more elder law attorneys look at it from a more holistic point of view. While you're alive, while you're incompetent, and while you after you pass away, what's the best plan for you, and how do we make sure that plan is put into action? And does your documents allow your agents, the people you have in charge, to be flexible, to be able to pivot, because we thought A was going to happen and really M happened. Now we need to pivot 180 degrees. Are we prepared for that pivot? So what I like to do is I like to talk to all my clients, and when I do presentations, about what documents do we need. And I've had these sayings for years. If you could say yes to these two questions, you need these documents. Are you over the age of 18? Okay, I'm going to assume everyone's saying yes. And are you breathing? Okay, another yes. So if you are over the age of 18 and breathing, we need these documents, which means our grandkids or our kids going away to college need them. Our kids that are in their 20s or 30s living in the city need them. This is not just because, oh, we're aging or we're retired or I haven't done it in 40 years. We all need them. Vicki, are you raising your hand? No, okay. So that's what's critical. So what documents do we need? Let's go through them so that way you guys have a general feel for what's going on. So the first document I'd like everyone to have, remember 18 and breathing, is the power of, is a Hipaa release. It's a general Hipaa release. This is a document that allows other people, whoever you would want, it's not limited, to call and get medical information about you. Well, and I get this, well, but I'm part of the AMITA group. I'm part of the Northwestern group. I've already signed it. Well, what happens if you go outside that AMITA group or that Northwestern or the Presence group? How are those people that you love going to be able to receive that information? So a general Hipaa release allows the people you name, and if you're married, your spouse could have different people than you have, name and state who could call and check in on you. Now that's very different than your power of attorney for healthcare. So the power of attorney for healthcare is a document that says, hey, if I need help making decisions, if I don't want to make the decision or I'm unable to make decision, who's going to be the person I want to step in my shoes and make those decisions for me? And it could only be one person at a time in Illinois in the order named. So again, you could have 6 people, but it can only be one person at a time in the order named. Again, the client I just saw this morning said, yeah, but I want both my friends to be together. I'm like, Illinois really doesn't allow that. It's one person. You can only have one captain of your ship. And what's important is if you have a Hipaa, you could have everyone get healthcare information about you so they could call, get that information. Or if you don't have that, it's only the power of attorney for healthcare that technically is allowed to receive that information. So they kind of work hand in hand. And I think they're both important, again, even for that 18-year-old, right? Because I could give you a scenario. My daughter was away in college, boy, at least 10 plus years ago now. And she ended up having a concussion freshman year. It was very bad concussion. And then junior year, she's a collegiate athlete. Junior year, she got hit in the head again. And they were very concerned because, you know, mom's an attorney and they didn't handle it the first time. So mom pitched a fit and now they're worried mom's going to sue them. So what do? They immediately take her to the emergency room. Her girlfriend calls me and says, my daughter is in the emergency room getting a brain scan. And I said, okay, let me talk to the nurse. And the nurse said, I'm sorry, mom, but she hasn't signed a release yet. And I can't give you any of that information. Even though she's on my insurance, I'm paying the bill, it didn't matter. She was able, I was not able to get information. So I said, great, again, 10 years ago, what's your fax number? Let me fax you the HIPAA. Let me fax you my power of attorney for healthcare. Because she's up in Wisconsin, I'm in Illinois. I wanted to get in my car and drive like a crazy woman up north, right? I wanted to get to her because if something's going on, I wanted to be there. And so once I faxed that document to the hospital, the nurse said, Mom, she's perfectly okay. You don't need to leave. I'll have her call you when she's done. There's nothing to be concerned about. So because I had that information, I wasn't driving like a crazy person up 39 North trying to get to my daughter. So again, it was really important in my world that I had this information. So that's the second document, power of attorney for healthcare. I also have other people who say, what's a durable power of attorney? So a durable power of attorney, we don't have in our document. A durable power of attorney saying it has twofold. It's durable. It does two things. It's valid while you're competent, and it's also valid while you're incompetent. So we need both those. But in Illinois, in Wisconsin, I believe, in Florida, in New York, they're called durable powers of attorney. We don't use that in our title. It's Illinois statutory short form, power of attorney for healthcare. So that's what we use. And the reason why I like to use what everyone's used to seeing is because it's statutory. That's what the hospitals are used to seeing. That's what they're used to seeing. And sometimes if we deviate, it just sometimes causes more confusion. So that's part of my reason. We could expand on it. We could add powers. We could do things to it, but I still like to use the same format. Excuse me. So what's important is that we have the document. Then I do like to give my clients what's called a living will. So the living will states that, hey, if death is imminent and there's no chance of recovery, you do not want to be kept alive because we could keep you alive today. But death needs to be imminent. So you fall down, you hurt your ankle, and you go to the hospital and they say, oh, by the way, Miss Dorjath, you have a living will. I'm like, is death imminent from my broken ankle? I need to go to a different hospital right now in order to get that. So for me, we need to understand what these documents do and why do they do them. So those three, HIPAA, power of attorney for healthcare, living will, are also called advance directives. So if you go to the doctor and they ask you, do you have your advance directives? Not one of them is called an advance directive, right? Not one. Can I get a cough drop? Not one of them is called an advance directive. So they don't understand what they're asking for. An advance directive is kind of the umbrella term for those documents. And that term also encompasses what we call a DNR. In Illinois, we now have what's called DNR/POLST, P-O-L-S-T, practitioner's order for life-sustaining treatment. Now, a mouthful, right? Absolutely. What is a POLST? So a POLST took place of the DNR. It's kind of like a DNR on steroids, and it's also part of the advance directives. Again, the difference between the POLST and the other three. It's a doctor's order. The medical community is supposed to follow it. Your power of attorney is not a doctor's order. What do I mean by doctor's order? A doctor gives you a prescription for high blood pressure. I make up anything. Well, now I bring that prescription to the pharmacist, and the pharmacist says, well, Nancie, you know what you need to do? You need to lose weight, and then you won't have high blood pressure. So I'm not going to fill your prescription. They can't do that. They have to follow the doctor's order. So the post/DNR is a doctor's order. Everyone in the medical community is supposed to follow that order. And that's critical for end of life issues. Now, I personally don't recommend, everyone does not need a post. Everyone does not need that unless we're diagnosed with an illness and we know life has a time period, that we know that with this, we have this type of time period. Because do not resuscitate also means if you have a heart attack, don't check my heart. Don't put a stent in. And most people say, well, no, I want that. No, if my heart stops, please start it. Because we could all be, resuscitated and fine to go 2 days later with our hearts. It's not 1954 where most people passed away from heart attacks. Most people survive heart attacks. So we want to be cautious of how is a DNR used? Why do we use it? And in what form is it used? So those 4 documents all deal with our advanced directives. Okay, so we have to be cautious of when you go to the doctor or the hospital or your loved one does. What isn't it? When they ask you, what do you have an advanced directive? What do they need? I don't like them having my living will, because to me, remember the living will, you fall down, hurt your ankle, they ask, death is imminent. Okay, it's only used if death is imminent. So if death is going to be imminent, your living will says, don't keep me alive. In my world, that's for the power of attorney for healthcare to read and say, okay, this is mom's wishes. In this situation, we know death is imminent. She doesn't want to be kept alive by artificial means. That's very different than the post. The post is a doctor's order. Everyone in the community, in the hospital community, and the medical community is supposed to follow it. So it gives us a little more control with our end of life. It allows us to say, do you want a feeding tube? Do you have additional orders, that additional requests you want? And let me explain to you what this means. So my girlfriend's brother was around 40 and he had terminal cancer. He tried every experimental drug. He was never married, no kids, and he lived with mom. And he finally said, I had enough. I do not want to prolong my life. So he signed a post. And in that post, there's a spot for additional orders. He put, I do not want chemo. I do not want any type of radiation. I do not want any type of experimental treatment. And the reason he did this is because my girlfriend's mom would have done whatever it took to keep him alive. And you have the right to make your own end of life choices. And if you can't do this, but you express your wishes to someone else, your power of attorney can sign the post on your behalf. And if you said you didn't want that, but you didn't have time to sign the post, your power of attorney can sign it for you. So those documents are part of what everyone needs. Now, everyone, remember, does not need a post DNR. It's only if life is limited. Then those 4 deal with the medical community. So it's important for our personal health. Then we have what's called the power of attorney for property. Okay. Again, power of attorney for healthcare, power of attorney for property. They're statutory in nature. What the heck does that mean? Okay, it means that our wonderful elected officials in Springfield drafted these documents and they didn't have a clue what they were doing. They're awful documents. Right? None of them are estate planners, elder law attorneys. They have no clue what they're doing. But financial institutions are used to seeing them. So we want to use them, but we want to tweak them. We want to make them better. But we don't really want, I don't personally, it's just my personal opinion. I don't want to deviate from what everyone sees. You go to a bank and you give them a new document that isn't the standard form, it's more likely to go to their legal department, have their legal department review it to verify that it meets the statutory requirements than having the standard form everyone's used to seeing. So for a power of attorney for property, if you have a form, if you want to look at the form, it's awful. Okay, so it states, Carol, let me see 1 second. Sorry, guys, I just want to see if I could pull up a generic one from the state. Carol, am I okay doing this?
Absolutely.
Okay.
Where's your assistant?
You know, I think we're going to have to make some changes around here. All right, 1 second here. All right, so let me go back. Can I share my screen, Carol?
Absolutely.
Okay, so I am going to share my screen. Hopefully. It's not letting me share. Do I need authorization?
No, you should be fine.
Share screen.
I need something else here. No.
No, it's not letting me.
Somebody else's. Okay, just all right. Try now.
Oh, now I can. Now it's blue. Okay, there you go. All right. So let me make this a little bigger for you. So here, it's power of attorney for property. Can you see that's the title from it, power of attorney for property. And what it does, let me explain to you this wonderful, terrible document. So here's what your power of attorney can help with, and it's listed here. It says A, B, C, it goes on, right? Real estate, whatever it may be. And then if you look at O says all other property transactions, right? So you're thinking, hey, if it's not listed A through N, O is going to catch it, right? It's going to be everything else. Well, let me tell you, O doesn't mean anything. So a lot of attorneys, a lot of other people who draft these don't understand the implication that O means absolutely nothing. Because let me show you number 3. So number 3 says here, in addition to the powers granted above, I grant my agent the following powers. Well, my argument is, why do we need to grant our agent more powers if they have all others, right? All other property transactions. Doesn't that mean everything under the sun? All others? Well, it doesn't, because number 3 is here. So number 3 says, in addition to the powers granted above, I grant my agent the following powers. And then it goes on to say, here you may add powers to make gifts, change beneficiaries, revoke or amend a trust. Well, wait a second. If you don't put that specific additional powers in number 3, your agent, that's your power of attorney, doesn't have it. It doesn't give it to them. So number 3, what my goal is to give my agents as many powers as possible, because we don't know what life is going to be like. We don't know what's going to happen. And in case of a crisis, we want our power of attorney to be able to step into our shoes, if you will, and do what they need to do to protect us. Maybe protect us from taxes, protect us and qualify us for governmental benefits, maybe to make sure you don't have identity theft. So this number 3 is critical that it's completed. And those dots there, a lot of times people will put none. Well, that's the worst thing we could have happen. My additional powers of attorney are probably another 8 pages long, because we don't know what they're going to need to do. Case in point, not many of my clients have it, but now I add cryptocurrency, right? Because there's this crazy thing out there called cryptocurrency. Well, how do we access it? Or PayPal accounts or eBay accounts? how does the power of attorney access that if they don't have the authority? They can't. They don't. We need to make sure that that specific authority is given. And we want to list as many things as we could think of. I'll give you another one. This was not good. I had a single person who had animals. I'm an animal lover. I'm an animal freak, right? We foster dogs. I'm surprised the dogs haven't been barking. We have lots of dogs. And I had one client who refused to pay vet bills because they weren't given that authority in the power of attorney. So guess what? Guess what I put in my power of attorney? The power of attorney now has the ability to pay for any and all vet bills, blah, blah, blah. Again, when life changes, these change. 15 years ago, we really didn't have social media the way we do. We really didn't have to worry about identity theft the way we do. And the wonderful thing is, if we want to revoke a trust or amend a trust or create a trust, we could give that ability to our powers of attorney. So let's say you were planning on doing a trust, but you didn't. Your power of attorney can now step in your shoes and create that document for you on your behalf. So this document to me is the most critical, because if my clients do not have a trust, if they have identity theft, if someone stole their checking account money, which I've had more than one time, I want someone to be able to call the credit bureau and say, hey, wait a second. They didn't take, my mom didn't spend $10,000 worth of chairs. And literally I had that happen to me. Someone bought all of these chairs from North Carolina and charged it in my account. And my credit card company actually flagged it and called me and said, did you make this purchase? No. The other reason why this is even more critical if you're married. So if your spouse has 401ks, IRAs, 403bs, any type of retirement plan, and you do not have this document, and you need to access your spouse's document, how do you do that? Most people are their spouse's beneficiaries. Well, let's talk about that. To be a beneficiary, someone has to die. Well, I had a case in Joliet where husband was 64, 62, and he had a massive stroke. He needed 100% nursing home care, and he had a very substantial, sizable 401k. So the funds weren't the issue. They were able to pay for his care. The issue was the wife could not access his 401k because it was his and only his. She's the beneficiary, but he didn't die. So how do you then go out there and access his 401k to pay his medical bills? You can't. So we had to go to guardianship court. We needed the wife to be appointed the husband's guardian so she could access his 401k money to pay for his care. Now, on top of everything else going on, now this wife has to go to court. Who wants to go to court when crisis like this happens? And every year she has to go back to court, report to the court, how is she spending her husband's money? So if she would have just had a power of attorney for property, that could have all been avoided. So to me, this document is so critical that I think we all need this document. It doesn't matter if you're 18 or you're 88. This document is needed for everyone. Anyone have questions yet?
I don't see any at this point.
Okay.
I could jump in with a comment if you don't.
Sure.
Mind.
No, not at all.
I think this is another reminder, if you would, as to the importance of who you decide is going to be your power of attorney for property or for healthcare, because I know you have many of these and I have many. I just had another one this week where, you're out for a glass of wine and maybe you don't have a lot of family members and you say, oh, I'm doing my documents, would you be my power of attorney? Or you say it to your aunt, or you say it to someone in your family and they say, oh, sure, no problem. And then we have a crisis, like you said, massive stroke or something happens. And really, powers of attorney, people with that don't sometimes realize what's involved when you get into all of these complicated matters. And sometimes you don't want to point that out to them ahead of time, but it's important to have a second person on there or another alternate as well. And I don't think people realize what can be involved. Everybody thinks about, like you said, dying.
Right.
So, oh, I'm the power of attorney, or I'm the person on the will that's going to make the decisions.
Right.
Well, they're not dead yet. So, I mean, that's quite harsh. I'm sorry to put it that way, but people don't think about that. So that has no bearing until something happens.
And the thing that I hear, especially with children, is people think, oh, well, mom loved me more. That's why I got the jobs to do. No, because this is a job. It is truly work. It's going to take time to do these jobs. And I can tell you, from being a power of attorney for healthcare for my mom and my dad, this is not something that you could turn on and off. You either are or you're not. And especially in today's medical community, I think the medical community is so hyper focused on their specialty. I'm a heart doctor. I only look at the heart. I don't look at rheumatoid arthritis. I have a knee issue. Well, you need to talk to your heart doctor. No one's looking at the big picture. So your power of attorney is now, I think, even more critical than it was 20 years ago, because they need to be up on all of that and be your advocate. The power of attorney is your advocate. They're the person saying, no, don't do this, move them, do this. They need better care, turn them, whatever it may be. So we want to make sure that our power of attorney is someone who you believe is able to do the job. You don't want to name a child if they're filing for bankruptcy, right? Because, maybe they're going to take your money. And so we need to be consciously aware of what's going on. And if they have the right guidance, if they know how to handle it, it will make it easier. Don't you think, Carol? If people really have someone, in a sense, to hold their hand or to explain the road you're going down, will make it easier.
Very much so.
Yeah. And I've seen families torn apart because the person who's in control isn't really willing to be in control.
Yes.
And that to me is the crime. So one other, I think, Carol, this was maybe one of your clients. I went to Huntley into Sun City. Mm-hmm. I had a client, and I went to their home, and I felt like I was the Christmas tree. I was plopped in the middle of the room, and everyone was around me. So I had mom, dad, their son, daughter, her sister, her brother-in-law, his sister. So they were all there. So I was on parade. And so we're talking about power of attorney for healthcare. And the mom says, here's who I want first, second, third. And she never names the daughter. And the daughter spoke out and said, Mom, why aren't you naming me? Because the mom says, you're not going to follow my wishes. And then the daughter proceeds to say, well, Mom, I truly believe one day they will find a cure for what you have. So I want to keep you alive, so that way you're alive for that day when there's going to be a cure. And the mom said, that's precisely why I'm not naming you, because she is not going to honor what her mom's wishes were or are.
That was my client.
Yes.
And yes. I was in that same position. I understand who you're talking.
Yes. So, it's really important. And it's the same thing, when we have children, who's going to be our guardian, right? I mean, you just don't want to name your best friend, and you want to name someone who has your beliefs, your morals, your ethics, your whatever it may be. Same kind of thing with the power of attorney. And when life changes, these documents are not stagnant. They should not be in play for the next 24 years. When life changes, these change. Let's say your daughter lives a mile away from you. Well, it made sense that your daughter was a power of attorney. She now moved to Amsterdam. Well, you may want to reconsider because of the time change, and she doesn't answer the phone all the time, and she's traveling the world, and she may not be the best person to name. Maybe we have to come in and update those. So it's really important, just as when you buy a new car, you have to buy new car insurance, right? You can't use your old car insurance for the new car. You have to get new car insurance. Same concept here. We need to make sure that we're looking at these documents periodically. And it's not as though I'm saying, oh, well, you're going to do them and you're going to die. That's not at all the point of all this. The point is to be prepared for the unexpected, to be prepared if the car accident happens, to be prepared if the heart attack happens. If the lightning strikes your house, you're prepared. You could call State Farm or whoever you have, and you're prepared. So to me, it's critical we're all prepared for the unexpected. And we have as much flexibility in these documents as we possibly can. We want to have more than one path. We just don't want to have A through O, all others. No, because that doesn't give us the ability of flexibility of saying, you know, we're going to off-road and go to A. And now we're going to take road Z. And now we're coming back and taking road C. So for me, these are so important. For me, they're almost more important than what happens when you pass away. Unless you have little kids and then we have guardians and stuff. But for most of my clients, that's not the issue. And then we have what's called our last will. So our last will states who gets your stuff when you die, right? The executor is the person in charge. Now, let me put a myth to rest. If you have a will, you still have to go through probate. Okay? Everyone here, you still go through probate if you have a will. If you don't have a will, you still go through probate. The difference is the state of Illinois has a will for you. You're going to use how they say your assets should be divided. If you have a will, you get to say how your assets are divided. So having a will does not stop the probate process. What does? Okay, so let's say you have an IRA. Let's say you have 2 IRAs and you have a mutual fund with Edward Jones. Okay, so those are your assets and you have a house. On your 2 IRAs, you have your 2 kids as beneficiaries. Now, I just told you I'm an animal freak. I'm going to leave all my money to the anti-cruelty in my will. But my 2 kids from my IRAs are going to receive the IRAs because it's its own will. It's its own path. So if we have a named beneficiary, it avoids what the will says. The will is only for assets that don't have a beneficiary. So I said I have 2 IRAs and I have a mutual fund with Edward Jones. But with my mutual fund, I put my 2 kids and my niece. Okay. So again, is the anti-cruelty going to get anything from my 2 IRAs or from my mutual fund? No, they're going to get nothing because I already directed who gets that stuff. So again, named beneficiaries do not go according to what the will is. So not only do we need to review our documents, we need to review the beneficiaries we put on these documents. Another good story. So I was just at my dad's. He is 84. I was at his house a couple of weeks ago, and he starts complaining to me. Him and my mom got divorced 35 years ago. And he starts complaining to me that my mom, his ex-wife, is the beneficiary of his life insurance from 1966. and he's mad at my mom that she's doing this. I said, Dad, you did this when you were married to Mom, right after you had a child. This was not something Mom did after you guys got married. Do you understand? You never changed who the beneficiary should be. But he was convinced my mom was doing something underhanded and that she was going to get the life insurance. So life insurance, whoever named beneficiaries are, they all need to be re-looked at. It's part of doing your plan. It's not just doing your will and you're done. It shouldn't be that way. It should be reviewing all of your assets. Now, I'm not a financial planner. I cannot give you financial advice, and I am not an accountant. I do not want to give you accounting advice. But we need to maybe loop those people in to make sure that your estate plan is the way you want it to go. Now, I have some clients who, I have my cousin, he is an orthopedic surgeon, a multi, doesn't even know what to do with all of his money. He's very wealthy. His sister is on the other spectrum. She has mental health issues. She hasn't been able to hold down a job her life. So my uncle left all of his money to the one daughter, not to the other. The reason being is because he knew that one daughter needed the money, the other daughter didn't. So in our will, what I put is, I'm leaving money to daughter A and I'm not leaving money to daughter B. It's not because I don't love you, daughter B, but it's already you're well taken care of. And this money is really going to be needed for daughter A for her care. So we could put whatever we need in that will to explain why you're doing what you're doing. Because again, when someone dies, the family is mad at the person who died and how they made the distributions. But they can't yell at you because you're dead. So who did they yell at? Each other. They're now mad at each other because mom left you her diamond ring and I wanted that diamond ring. And dad told me I was getting the diamond ring, but mom left it to you. Now the sisters don't talk. So if we can put in there, I'm leaving Mary the diamond ring because A, B, and C, and Sandy, I'm leaving you this. This is why. So again, explanations help families, and they help not divide families or break families up. Does that also make sense to everyone?
Very much so.
Thank you, Carol. And so a last will, we still have to go through probate. Depending on the county you live in, is going to depend on how complicated it is. I truly believe Cook County is the most complicated, King County, the least complicated. King County, we never go to court, don't ever have to see a judge. Everything's done electronically. It's a pretty simple process. Back when I started working in this field in the mid to late 80s, we were able to get a percentage of every estate. It was a very lucrative profession. Now we can't do that. Now we get an hourly fee, which if you charge too much, the judge will knock it down. I'm going to say if the family doesn't argue and doesn't fight, and it's a pretty simple process, it could be anywhere from $3,500 to $6,000. More in the low end if everyone gets along and there's no issues. But again, it's not the money we used to make as attorneys when we were able to get percentages. That was a really great gig for attorneys. Okay, probate's the process to verify you died, to verify what your debt is, who you owe money to, who your beneficiaries are, what your assets are. So we need that. Probate is a great process, and sometimes it's even a better process if families are fighting. Because why? We have a judge now who's going to be they're going to have to go in front of a judge and argue. And let me tell you, I truly believe people act completely different when there's a judge in front of you than just their siblings. They act different, they talk different, they're more respectful. So sometimes probate isn't a bad process. Sometimes probate is a well-needed process, and it really does help when families are really arguing. It could also, though, drive up attorney fees. So we want to be, again, yeah, go ahead, Diane. Carol, can you unmute Diane? Or Diane, can you unmute yourself? Oh, you're still muted.
Oh.
There you go.
Okay. Just wondering, you said every time everything needs to go to probate. Is that correct? What happens? I thought that there was, if things were in a trust, that that does not go to probate. Is that correct?
Correct. That is correct. So remember, I just said if we have a will, that will needs to go through probate. if we don't have a will, and like, you know, there are some people who die without any, without any documents, that still goes through probate. If we have a revocable living trust, so it's a living trust, a revocable trust, revocable living trust, they're all the same thing. David? He's not listening, Carol. Can you get me my box? Oh, here it is. See, he heard me. Okay, so here's my trust. You see my trust? This is my little treasure box, right?
I don't see anything here.
Okay, do you see it? No, hang on, hang on. I will share my screen once again. Carol, can you let me share it?
Yeah, you should be fine.
It's not blue.
I'm not seeing you at all, other than in the small little.
Okay, can you see that? Does it say Nancie's Living Trust? Carol, can you see that?
I can see it. I think it's on Diane's side.
Diane, can you see me, Diane?
I have a small little picture of you up at the top, just a static one.
Well, I have this box and it's empty, right? There's nothing in my box. It's my trust. So what a trust is, I own a house and it's in Nancie's name. If I want to put my house in the trust, so I don't know if you could see, I have my house here, right? It's my house. Now, instead of being Nancie's house, it's going to be Nancie. It's going to come from Nancie's house and go into my trust. That's what's called funding your trust, transferring the name of your asset and retitling it into the name of your trust. Because if it's not in your box, if it's not in the trust, then you've just paid me a lot of money for this pretty box and it's empty. So what we want to do is we want to take my house, retitle it into Nancie's trust. We want to take my Michigan property cabin, put it in my trust. We want to take my mutual funds and put it in my trust. We want to take my stock certificates and put it in my trust along with my cash. Now my trust is full of stuff, right? So when I die, there's nothing in Nancie's name. Everything is in Nancie's trust. So now, even though my will, let's say I buy a cabin in Wisconsin and I forgot to put it in my trust and then I die. Well, now I need probate to put it into my trust. So probate is the way to put it into your trust if it's not in there now. So the whole purpose of a trust is to put stuff in it, to fund it while you're alive. You do not wait until you die. The only people who make out are me, the attorneys. We make out because you pay us to make this beautiful thing. Then you pay us to go through probate to put it in this beautiful thing that you could have done while you were alive. And then the trust is now the document who says who gets your stuff. So now you have a will that's only if you do an oops, forgot to put it in there, it goes in here. The trust is the document who says who gets your stuff. So yes, this trust avoids probate as long as you have all your stuff in here. Now, what doesn't go in here? Let's say you have your IRA and you don't want to put your IRA in the trust. That's the named beneficiary. So I'm still leaving all the stuff in my trust to the anti-cruelty, but my IRAs are going to my kids. So the anti-cruelty in my trust is not going to get my IRAs, because if you think about it, it's its own IRA, it's its own path. It goes to whoever we name as a beneficiary. So some of my clients don't need a trust because they have beneficiary designation on all their accounts, and then they have a house. Well, we can use this for your house. We could use a transfer on death instrument, which says, like your 401k, when I die, here's the beneficiary. And it allows us to put a beneficiary on our house. We could do a land trust. A land trust is very similar to this, but it could only put Illinois real estate. Can't put your stocks, can't put your Wisconsin property. And it allows us again to put a beneficiary on it. So we don't need the fancy box because everything has named beneficiaries. So that's why I'm saying it's really critical that you spend time with someone who understands A, what assets you have, B, what your family dynamics are, because maybe you have a disabled child and you want to make sure that disabled child, when you die, has like this cute little box of their own. So all their money, instead of going directly to them, is going to get protected in their little box. So depending on each family's circumstance is going to determine what's the best plan. I don't believe in Susie Orman, right? Susie Orman says, you need a box and you need a trust and you need a trust. That's not true, because based on your situation should be based on what documents you need, not because Susie Orman tells us so, right? I mean, she's a smart, multi-million-dollar woman who sells products that we all don't need. Now, we've all bought those, whether it's face cream or whatever, we all bought into it. I'm trying to tell you, don't drink the Kool-Aid, okay? So to me, it's really critical that everyone has the first 4 documents. Remember, Hipaa, power of attorney for healthcare, living will, power of attorney for property. Then we all need a last will, but some of my clients really have very little means. Maybe there's a way to get around it. Some of my clients have a lot of means. Maybe this is the right way to go. Maybe they have special needs children. It's a different scenario we're looking at. So again, this is individualized treatment. I try not to be the doctor and say, okay, what happens when you die? We're only going to cover this. No, it's the holistic point of view. What all your assets are, what's your family dynamics? Do you have a spendthrift? Do you have an alcoholic? Do we need to protect that child? Adult child at 52, whatever that may be. We need to figure that out in order to give that to someone. Does that all make sense to people?
I think it does. And we have about 4 or 5 more minutes, Nancie.
Okay, does anyone have any questions on my box? Beth, anyone? Okay, so what's our takeaways? Takeaways are advanced directives. Figure out what they really want. My daughter-in-law just graduated from nursing school. She is at Loyola. The nurse that was teaching her about advanced directives didn't even know what she was talking about. So now we have these kids graduating and they don't know what they're talking about. So we need to make sure that you're asking them. They don't need your living will if you're going in for a small procedure. To me, that doesn't make sense. Who do you want to be able to, your powers of attorney? You better trust them. And then last but not least, we do have ways to protect assets if we ever need Medicaid, if we ever need long-term care. If some of us don't, most of us don't have long-term care insurance, most of us don't have a great pension. How do we pay for long-term care? Do we want to deplete all of our assets and then qualify for Medicaid? Because a lot of people think, oh, if you go in a nursing home, you're going to pass away quickly. It's the complete opposite. They're paying attention to your blood pressure. They're giving you the pneumonia shot. They're giving you the flu shot. They're making sure you stay healthy. People don't die as quickly as we think when they go into nursing homes. I believe, Carol, is the average at least 3 years?
Minimum of 3 years.
Minimum in a nursing home.
Average of 3 years, yes.
We're not talking assisted living before that. So we really need to pay attention to how do we protect our assets? Do we have the ability to make sure we don't spend every penny if you don't want to? Now, if you want to, that's a whole different ballgame. We want to make sure we spend every penny. But if you don't want to, does your power of attorney have the ability to protect those assets? And that's critical, because real quick, I think I have a minute left. Real quick, let me tell you my story about why I do what I do. Born and raised Chicago kid. Don't know if you pick up the accent, but total Chicago kid. Raised with my grandmother. She lived in the basement. ethnic were Polish, so she was Busha. Busha lived in the basement, and I did what every Chicago kid did when they got married. I moved across the street, just like everything but Raymond. Swear, it was just like that. So Busha would walk across the street every day, babysit my kids while I was in law school. And when we moved out to the suburbs, Busha moved with us, first floor bedroom, first floor bathroom. She ended up, her dementia got so bad, I could not take care of her. Well, we had to place her in a nursing home, and I did not know we could protect her assets. So I did. The middle class is the class that obeys. I did what I was told. The nursing home said, spend all her money. When she's done with her money, she'll qualify for Medicaid. I did that. She lost her dentures. I didn't have money to buy her dentures. Medicare doesn't buy dentures. Medicaid didn't buy dentures, nor did her supplement insurance. She had to go without teeth for the rest of her life. Now we're talking about end of life human dignity. I am not talking about her having a cruise for the end of her life. I'm talking about her being able to chew her food. So I do this in order for people to have end of life human dignity. If people want to give birthday gifts, Christmas gifts, wedding gifts, they're able to do that. So this to me is so important for everyone to understand what we can and can't do. And we can't do it if we don't have the right documents in place in order to do that. So that's what I have to say. If you have any questions, please feel free to contact Carol. She could give you my information. Carol, I'm not sure if you put it in the chat.
I did. I put in your contact information.
Thank you.
Nancie Dorjath, Dorjath Law Center, and put in the ElderWorks information to contact me as well. So. But Nancie, thank you so much. Very informative as always, and great to see you, even though it's virtual.
Exactly.
And yes, we thank everyone for joining us today. Please keep ElderWorks in mind if you have further questions that we can help you with, and also contact Nancie direct at Dorjath Law. And have a fabulous day, everyone.
Yes, enjoy the day. Thank you so much, everyone. Bye-bye.
Bye.